Hello, I'm still Stephen Gold, the author of The Return of Breaking Law, and if you haven't read the book, please raise your hands. Sorry I asked. A peppercorn. Something the whole family can enjoy. Perfectly delicious if ground over a piece of undyed smoked haddock, though of little value to a landlord. But for landlords granting residential long leases, that's for over 21 years, of flats and houses in England and Wales, that's the maximum amount they can charge up for ground rent as from the 30th of June 2022 under this year's Leasehold Reform Ground Rent Act. Effectively, ground rents are banned under new leases if for more than a single solitary peppercorn. The peppercorn is symbolic and the law's way of saying ground rents have had it. But leases will escape the ban if granted before the 30th of June or granted after that date under a binding contract that was made before that date. The new law won't apply to leases of retirement homes for the time being, although it will be extended to them sometime after March of next year. There are a few exceptions to the ban applying to new leases, principally in relation to statutory lease extensions. And with shared ownership leases, the peppercorn limit will only apply to the tenant's share of the property.
What happens if the new lease requires a ground rent of, say, £500 a year?
Well, that will be unlawful. The landlord can be penalised by the local authority, and that's for up to £30,000. The tenant could ignore any demand for the money, but should the tenant misguidedly pay up, they can get their money back with interest at the rate of 8% per annum. Small claims in the county court are not for peppercorns. Well, not usually. To be dealt with under the small claims procedure, when, more often than not, lawyers keep out, they can be for up to £10,000. Now, for a trial period which started on the 1st of June 2022, certain small claims will be decided on paper only, even though the parties or one of them objects. No attendances by anyone except the judge, though on a hot day they may be deciding the case in a cold bath, and a decision based on the paperwork lodged by both sides and, of course, based on the law. Now, if the trial is a success, you can bet it will be extended to all county court centres. For the time being, it will only apply to small claims dealt with in the centres at Bedford, Luton, Guildford, Staines, Cardiff and Manchester. Now, this isn't a trial I favour. There's no substitute for letting the judge see the whites of your eyes and hear the passion of your voice, unless, of course, you're talking complete rubbish. However, the judge will have a discretion in these courts about whether to direct an all-paper decision or not. It won't be directed if live evidence or the oral arguments of the parties are necessary. Flight delay claims and claims by parking ticket issuers are likely to be prime candidates for paper only. There will be opportunities to object to being deprived of a day out at court, but the best way of being sure to avoid this trial procedure is to try and steer clear of all 6 of the court centres at which it will be operating. You haven't got any court claims coming up, have you, Mr. Producer?
I was thinking of suing you for defamation of character.
I didn't realise you had a reputation to protect. Just teasing him. We've had a debt respite scheme going for the last year. If you need time to put together a plan to pay off some of your debts or get together some cash, you can apply for a moratorium, usually through an approved debt counselling service, during which whoever you owe money to, that's your creditor, cannot take any action to enforce the debt. If there's a bankruptcy hearing listed, it will be adjourned until the moratorium has come to an end. There's a breathing space moratorium, which lasts for 60 days, and a mental health crisis moratorium, which lasts for the period of the crisis plus 30 days. A register is maintained which records each moratorium granted, but the court may not know of the existence of the moratorium until the debtor or creditor tells them about it. Some debts escape the paralysis of a moratorium, mainly certain business debts where the debtor is VAT registered or in partnership, and secured debts, though mortgage arrears can be protected by it.
Let's say the creditor takes enforcement action when that is prohibited because a moratorium has been granted.
Well, you ask all the right questions sometimes. That actually takes me to a case that's just been decided by the High Court. Now there, the creditor had a judgment which the debtor failed to pay. The debtor owned a flat. The creditor obtained a charging order against the flat through a court order. Still, the debtor failed to pay up. The court then ordered that the flat be sold with a view to the proceeds of sale being partly used to satisfy the judgment. The debtor was evicted and the flat sale went through. But when the eviction and sale took place, a mental health crisis moratorium was in place. The creditor didn't think that it stopped the enforcement. Well, the High Court's just ruled that it did. The eviction and the sale were null and void. The debtor gets back into her flat and 101 headaches arise over money paid over by the flat purchaser and their lenders.
And the moral is?
Well, creditors beware before enforcing when there is, or there might be, a moratorium in place. Elsewhere in law land, if you and your partner or former partner have an ongoing dispute about the welfare of your child, it may be possible to resolve that dispute through mediation. But mediation costs money. The government, though, will contribute by way of a voucher £500 towards the cost of some mediation sessions, and the scheme is not means tested. A further £5,400,000 is being injected into the scheme. It's just been announced. You can find out about the scheme when you attend the generally compulsory mediation information appointment before you start off any Children Act proceedings in the family court.
Why is the government so keen to give this money away?
Well, because it's cheaper for them than having parents fight out their differences in court. Cases could take so many days and lead to so much acrimony. For the parties to a family case who have lawyers on board, the costs can be punitive. In civil cases, it's long been possible for a defendant to ask the court to order the claimant to give what's called security for their costs, where they look to be behaving in a dodgy way, or they reside abroad, or if a company, there's reason to believe they couldn't pay the defendant's costs if the defendant was victorious and had costs awarded in their favour. The claimant would have to pay to the court a sum of money which could be used to satisfy a cost order or come up with some other form of security. Well, the High Court has just made what appears to be the first ever order for security for costs in a family case. In fact, a Children Act case. The father of an 8-year-old child was applying for his son to be returned from Toronto to him, the father, in Dubai, where he was living. He was ordered to stump up £50,000 to be held, this time not by the court, but by the mother's solicitors as security for any cost order she might obtain against him at the end of the case. The judge said that to make such an order in a family case, the court would have to be satisfied that there was a real risk that the other party wouldn't be able to enforce a cost order without that security. And on those new no-fault divorce laws, if you and your partner are sharing the court fee when you start the case off, the court will only collect that fee from one of you. So if, say, you're jointly applying for a divorce, one of you will need to collect the other party's contribution and pay the lot over to the court. And if the other parties promise to join with you in asking for that divorce, and that's possible under the new law, and you indicate this online when you start the case off, but they then fail to do anything about it, you can restart the case on the basis that you alone are going to pursue freedom, and you won't have to pay 2 lots of court fees. Well, that's it till next time. And remember, you can always use my book as a sun hat when not reading it, but it's a bit heavy. Goodbye.